oh yay, oh yay. This Honorable Court of Appeals of Tennessee is now in session. I say the United States.
Good morning. Nice to see everyone here looking eager to get started. We have 3 cases on the morning docket. We'll hear them in the order in which they appear on the docket. For the appellants, when you come up and after you introduce yourself, if you want to reserve some time, up to 5 minutes, you may. You don't have to. Totally up to you. I don't think we have any announcements this morning. I don't see anybody wanting to get up here. So would you call the first case, please?
Christine L. Manion et al. Versus the Baldini, Pryor, and Lammert Partnership.
Good morning. May it please the court. Thomas McFarland here on behalf of the appellant, the Baldini, Pryor, and Lammert Partnership. May I please reserve 3 minutes of argument for rebuttal?
3 minutes, okay.
In this state, the right to acquire, hold, and enjoy private property has long been recognized as absolute. This court, in Holt v. Fisher, described that right to own real property and enjoy the benefits of ownership without interference from others as, quote, one of those rights held most precious by the citizens of our state. The trial court's judgment in this case is contrary to this fundamental tenet as well as to controlling Tennessee law. As such, the trial court committed reversible error when it imposed an easement by prescription across the entirety of the partnership's real property located at 1335 West Main Street, Franklin, Tennessee. Respectfully, there are at least 4 reasons why the trial court's decision below should be reversed and remanded with direction to enter judgment in favor of the partnership. The first of those reasons is that the plaintiff's proof at trial failed to establish by any measure, but much less by the required clear and convincing evidence standard, each of the necessary elements of a prescriptive easement for the entirety of the 20-year prescriptive period. Second, the trial court's decision incorrectly established by implication a principal-agent relationship between an unidentified individual and the partnership, which is contrary to Tennessee law. Third, the trial court erred when it permitted the plaintiffs to tack their ownership onto their predecessors in interest ownership, the Ray family, in the absence of any deed or other document establishing the existence of an easement or reasonable reliance as required by Tennessee law. And finally, the fourth reason, the trial court's decision improperly relies on irrelevant factors in imposing the easement. The facts of this case are set forth in the briefing, so I will refrain from reciting them with the exception of a timeline that is relevant to the argument. That timeline started in 1981 when one Hermsworth Gardner purchased 1335 West Main and constructed an office building to serve his practice. Later that year, on July the 7th, 1981, he entered into a lease agreement with the Ray family, who owned the property immediately adjacent at 1337 West Main Street, Franklin, Tennessee, for the back portion of that lot in order to construct a parking lot to be accessed by 1335 onto 1337. The term of that lease was for 5 years. It ran until July of 1986. Shortly thereafter, Dr. Gardner vacated the property and closed his practice. The next intervening event in this timeline is October 1999, when the predecessor of my client, the partnership, purchased 1335. That entity was known as Willowbrook Health Systems. Willowbrook acquired 1335 in October of 1999, performed renovations on the property, and occupied it shortly thereafter in early 2000. 2 years later, in 2002, the partnership formed and acquired the partnership was formed and acquired 13335, and then it was sold in 2014. This incident arose in late May or early June of 2018 when access to that parking lot was blocked by one of my client's contractors, followed by a letter demanding that they cease and desist any access across my client's property. In March 26 of 2019, the plaintiffs filed their complaint, and my clients filed their answer and counter complaint demanding ejectment in May of 2019.
Counsel, I have a question about one of the aspects here in terms of establishing a prescriptive easement. The language claim of right pops up in your brief. Is claim of right actually a distinct requirement in Tennessee from hostility, or is it essentially just another way of saying hostility in Tennessee?
No, Your Honor, it is distinct. And if we look at Blakemore, which we would submit that Blakemore v. Matthews and his progeny control this dispute. If you look at Blakemore, in that decision, this Tennessee Supreme Court specifically points out that one must first prove adverse use, and second, the claimant must also prove that that adverse use was under a claim of right.
What is a claim of right then, counsel? What is it that you have to show to establish a claim of right under Tennessee law?
Claim of right requires that the plaintiff or the claimant supporting the prescriptive easement puts defendant on notice that he claims a right to do whatever he's doing, the access, rather than that being permissive.
How is that different than hostility, though? Open, obvious, hostile. And I'm trying to find the daylight between claim of right and open, obvious, hostile. Those seem like they're essentially covering the same terrain here. So what's the division between them?
Adversity and claim of right certainly go hand in hand, Your Honor. But Blakemore is very clear that the claimant must satisfy all of these elements and that adversity and claim of right are distinct.
What is a claim of right?
It is placing the true owner on notice that you're not doing this, you're not accessing this permissively, that you claim the right in order to do it now and forevermore.
So you have to march up to the owner and say, I have the right to do this.
No.
Right? What about doing it for 20 years?
Well, Your Honor, certainly not
open and notoriously.
Certainly not the first aspect. You are not required to march up to the owner and pin a letter on their chest to say, we claim this right.
That would be assault.
There must be something that puts that owner, whether it's explicit or implicit, of the claim of right. And Blakemore and Bowles are very clear that it will not be presumed. And the reason that is controlling in this case, Your Honor, is because from 1986, when Dr. Gardner vacated 1335, through October of 1999, we have no proof as to what type of notice or what type of actions took place with regard to the interim owners of 1335.
Well, can't we infer from, say, the owner of your properties building a new fence and leaving that access to the property, which they don't own, open?
Well, Your Honor, I would submit that no, we cannot infer that. But additionally, even if we did, that fence remediation took place in 2011. The gap in plaintiff's proof exists between 86 and October of 1999.
But counsel, hasn't plaintiff presented evidence that from the time the lease ended with the doctor, that they've been parking cars in that parking lot since, 1986, that they've been driving across this property, pulling in there, parking their cars, whether it's mom or son or somebody visiting. And the trial judge just didn't believe that this was only noticed once in 2017 or 2016 or wherever the defendant says they first noticed this. And somebody's been driving across there since 1986. And isn't that open and obvious and hostile? I mean, we're not talking about hundreds of acres out in the middle of rural Tennessee. We're talking about some parking lot you drive into and you've got the, best I can tell from the exhibit, the windows looking out onto where you're pulling in. Isn't that open and obvious?
Your Honor, with respect to the trial court's rejection of that testimony, we are not challenging the credibility determinations there. We reference it in our exhibit or in our briefing, but that occurred post October 1999. There's no proof presented by the plaintiffs as to what occurred or what the interim owners of 1335 between Dr. Gardner, then there was the bank, and two successive more owners of 1335 before the Willowbrook Home Health Systems purchased it in October 1999. So even if we assume that on the date of purchase, October whatever of 1999, that each of these elements are met, we still only go forward 19 years and 5 months. And as established in Sheely v. Williams case, you have to establish each of these elements for the entire prescriptive period. There's got to be a definite starting point. So the plaintiffs were required to put on some proof as to each and every element of a prescriptive easement for the entire prescriptive period.
But wasn't it in 77 or 78 that the carport was enclosed as a structure? So wouldn't we know for sure after 78 the only way to get to that back parking lot was through your client's property?
Well, in 77 or 78, there was no parking lot. It was constructed in 1981. Right. So after 1981, that's how the parking lot was accessed pursuant to the lease with
only through your client's property.
Only through our client's property. And the proof is uncontroverted that once the lease ended and Dr. Gardner vacated the property, a chain was placed up with a no trespassing sign, blocking with only the plaintiff's predecessors in interest having a key to that sign. So the intervening gap there is what is problematic for the plaintiffs.
Wasn't that chain taken down by one of the Rays?
No, the chain was not taken. The chain was taken down by the Rays, according to Mr. Ray's testimony, when he drove in and out. But it was eventually removed entirely by my client in 2018 and replaced by his own. But again, Your Honor, we come back to the issue of there is no proof of all of the elements for this full 20-year prescriptive period. And Gammo v. Rowland, the Gammo v. Rowland case expressly says that these have to be, each of these elements have to be proved for the entirety of the prescriptive period. Sheely v. Williams also says that the claimant must show each element, quote, for at least 20 years without a hiatus and in a manner consistent with the legal requirements. Here, plaintiffs showed use, and the trial court extrapolated use to mean all these other things. But we don't have any proof in the record to support adversity under a claim of right, visible, exclusive, etc., as to these interim owners. That's the problem, Your Honor. Your Honor, even if we reject Mr. Lammert's testimony entirely, even if we reject all of the Willowbrook employees' testimony entirely.
And you're not challenging the credibility determination as to Mr. Lammert, right?
We make reference to it in our brief, but we recognize that the trial court is in the best position to make those determinations. But the point of our position, Your Honor, is that even if you reject every single piece of evidence put on by the partnership, we still have October of 1999 as the earliest possible date that this adverse conversation between the unidentified individual. Do you mind if I finish my?
You finish your statement.
October of 1999 as the first date that this conversation between the unidentified, purported agent of the partnership and Wayne Ray. So even if that occurred on the first date that my client's predecessor took ownership of the property, we still only have 19 years and 5 months, Your Honor. Thank you.
Thank you.
Good morning, Your Honors. Larry Crane here on behalf of the plaintiffs' appellees. As easement cases go, this one actually was pretty interesting. The facts were relatively uncontroverted that this property, and I represent the dominant estate, had been owned by the Rays since 1962. They lived there all of their lives. And the proof that came in was most interesting, I think, from Ms. Ray's two sons, Wayne Ray and Robin Ray. both of whom testified to an unbroken chain of access across the defendant's property to park in this parking lot. I've heard discussion this morning about the question of whether or not there was adversity, and I point the court to the case of Thompson versus Helse, which we cite 2 or 3 times in our brief, which involved property, I believe, in Ray County, and there had been unbroken access for a period of 20-plus years across a paved section of the church's property. The question here is whether or not the existence of a landlocked parking lot, essentially, there's no dispute, the only means of access to which was across the servient estate, would put on notice the owner of the serving estate that this use was adverse or posed a claim of right, to use my opponent's phrase. The question here is, I think, unmistakable that as Sherry Howell testified in this case, if you may recall, Sherry Howell is a lady who moved directly behind the Ray's property. She did so back in 1985, and she testified for 30-plus years she could look out her back window and that she saw cars regularly parked in this parking lot behind the Ray's, in the rear of the Ray's property. Wayne Ray, who testified that in 1986 he began parking his vehicle there and did so right up to the time he sold the property to my clients in 2015. There were aerial photographs in this case that were actually dated during the relevant time frame, which showed Ms. Imogene Ray's car parked in the parking lot to the rear, which showed other vehicles parked there.
When the original agreement was made for construction of this parking lot to be used by clients of the owner of 1335, was there any express agreement in the lease itself about use of it after the term of the lease?
No, Your Honor, there was not.
But he left open the access to it through his fence, and so can one infer that there was some tacit, at least, agreement that it could be used, or was there? I mean, is there anything you can infer from leaving it open, the fence open, so that you can get over there?
There was, I think, a reasonable inference that could be drawn, given the fact that not only was that gap in the wooden fence left there by Dr. Gardner, but when, as the court noticed earlier, the fence was restored or repaired or replaced, Mr. Lammert again left that gap there. There's an
even put in a little piece of fence across 1337's property to connect it to a shed or something to enclose the back.
There was, but it didn't block vehicular access.
Right.
Right.
It was just a little bit of a friendly trespass.
Friendly trespass.
Okay.
Interesting footnote to that. When Mr. Lammert bought the property in 1999, he had a conversation with Imogene Ray. He went to her to essentially get the same deal that Dr. Gardner had to have access to park in this lot, and Ms. Ray wasn't having it. She said no this time. But that served to put him on notice, certainly, that there had been this prior course of dealing between the Rays and Dr. Gardner. I don't think that anyone looking at this property, the court made a special trip out. Judge Woodward made a special trip to the property to do in kind of a look-see himself. And if you look at all the photographs that came in during this trial, it's unreasonable to expect that a person standing on 1335 and looking in the direction of the 1337 property couldn't be on notice when vehicles are parked in that parking lot. Several of the Lammert witnesses were employees who testified they took smoke breaks out there, and that during the time they were taking a smoke break, they could clearly, visibly see that vehicles were parked there.
Counsel, I have a question, same question as to opposing counsel with regard to claim of right. Is claim of right really distinct, or is it just another way of saying hostility, open, obvious? Is it really a separate, I mean, there are series of listings in Tennessee where claim of right will appear. There are series of listings where it seems to disappear in terms of prescriptive easements. I'm trying to figure out, is it actually different than open, obvious, hostile, or is it really just another way of saying the same thing?
There's perhaps a nuance between the two. Let me suggest this. If you look at this case of Winquist versus Goodwin, the court dealt with this issue in the context of tacking, but whether or not there was parole, there's two ways to establish essentially claim of right. One is through the deed itself, if it makes reference to such an access. The second would be through parole evidence that the owner of the dominant estate reasonably relied upon representations made by his predecessor that established a prior right. Now, in this case, there was testimony by Robin Ray, the predecessor, with Ms. Manion and Mr. Alford, that when they purchased the property, they relied upon Mr. Robin Ray's statements and representations that there had been a prior history of several years of access to this lot. And that was critical because this parking lot was a very material element to purchasing the property by Ms. Manion. They wanted this to be rental property, commercial rental property. And to market this property, they needed adequate parking. And there wasn't adequate parking in the front. There could maybe get one or two cars in this driveway. So the fact that there was access to this parking lot by their tenants, and there was constant access by their tenants, was an important aspect of their contract to purchase this property. I hope I've answered Your Honor's question. But we believe that the proof is, when it comes down to it, there's a question of credibility, and the court found that Mr. Lammert's claim that he didn't know about the appellee's access to this parking lot until sometime in May or June of 2018 was simply not credible in light of all the overwhelming evidence of open and continuous use and access by the appellees and their predecessors. My opponent makes reference to the fact that Wayne Ray placed a chain across this, but I believe that evidence goes to our favor because it shows exclusivity. In other words, this parking lot was not available to the open public or anyone who wanted to drive across the Lammert property. The Rays made sure that it was reserved for their use and their use only, as did Ms. Manion for her use and her tenants' use only. So that's a component that is required under the elements for a prescriptive easement as well.
Counsel, for the start date for the prescriptive easement, is that something that you would put it in 1986 when the doctor ends up no longer using the back parking lot? Is that our beginning date for the prescriptive easement here? I
believe that it is. Now, that goes far in excess of how much time is needed. Of course, that's 32 years as opposed to 20. But there is no gap, I would contend, in the use of this parking lot. There simply is no evidence that there was a gap.
No, he's claiming there's a gap in the notice, whatever that notice is, to the owner of the office building, of the claim of right. And he's saying it's got to be more than just use. Do you have any thoughts on that?
I do.
I thought you might.
I think that if this were, as Your Honor, one of you mentioned, a rural county, 500 acres of property where there wasn't, you could perhaps scutter across someone's land without them knowing it, would be a different scenario than what we have here. This property is 3 blocks off the square in Franklin. It's a commercial piece of property. I bet all of you have driven past many times. And it's clear that there's no way that one can regularly park in the back of this lot without it being notice to the owner of 1337. And that would be true throughout the chain of title, whomever's occupying that property after Gardner sold it. So we think that the circumstances of this case are such that it creates not only open, notorious, continuous use, but adverse use and notice to the owner, and that as the trial court found.
So are you suggesting that without that solitary encounter between Mr. Ray and someone with 135 West Main, we don't know who she necessarily was affiliated with, there would still be adversity?
I do. That would be our contention. Now, with regard to this exchange between Wayne Ray and the representative of Willowbrook, the court, and you can draw whatever inference from that, but clearly the person who told Mr. Ray, stop crossing our property to park your cars, Mr. Ray responded in less than a polite manner to her that it was his property and he would drive to it however he saw fit and whenever he saw fit. But that does establish that a person who held themselves out as a representative of Willowbrook didn't want someone driving across that property. And Mr. Lammert can disclaim knowledge, actual knowledge, but I think there's some reasonable inference of imputation of that knowledge to the owner of the property, was their representative.
Counsel, is there a problem with how the scope of the prescriptive easement has been framed by the trial court here across the expanse of the paved area, and that seems impressively large in scope to cover just the traversing it to the back parking lot?
I would agree, except for the fact that there is ample testimony in the record of the precise course or path that was taken, and it was along the fence, the wooden fence that we've talked about. The access was, and I think there's even a photograph where I asked one witness, is this the manner in which you drove, it may have been Robin Ray, across the 1335 to get to the parking lot? And no one testified that they drove all over the paved area.
Has the trial court then stated the scope of the easement too broadly in terms of imposing potentially an improper limitation upon the estate 1335 estate owner's ability to use their property?
I don't believe that it's overstated or broadly stated it, but because it has limited it to the same manner in which it has been used and exercised over the last 32 years.
There's only, is there more than one entrance to that parking lot? I mean, the big one.
There is.
Okay.
There's one further closer to town that you can access. In fact, okay. While it wasn't relevant at trial, there have been people using that second one as well to access what was a radio station over there behind the property for a while. We ask respectfully that the court affirm the trial court's imposition of this prescriptive easement. If there are no more questions.
Let me ask you one further question. With respect to your clients, when was its first used as a commercial property?
In 2015, when they purchased this, the property was zoned as office residential, and which permitted commercial tenants. And there was, from the very beginning, a clinician or doctor or counselor, I think, that they first leased the property to. Very good. Thank you, Your Honors.
Thank you, Mr. Crane.
Just briefly, I wanted to respond to the initial question about what makes it, what's under a claim of right. And I wanted to come back to it. The Boyd v. Hunt case, it's from the 1800s. It's actually cited in Blakemore. It predates Blakemore. But Boyd v. Hunt says that the claim of right has to do something to quicken the owner into the assertion of his right. So that's what makes it distinct between the adversity. The adversity is the ownership interests. The claim of right is the assertion of that adversity. And I wanted to also reiterate that Blakemore distinctly separates those two out into the first place and second place, with the first place being that the adversity and the second place being under the claim of right.
So an assertion, the assertion is by the person claiming to use it, right?
Use it adversely.
So if the owner or the owner's employees see someone drive across the property, their property to get to another property, isn't that an assertion?
Well, Blakemore would state that the law in this state presumes that that use is permissive and that the burden lies with plaintiff to establish adversity and under a claim of right. And my opponent mentioned what their contentions were several times about what was shown in this gap of proof. The trial court was the time to prove these things. And there's no proof as to what occurred and what was on notice and what claim of right was asserted between 1986 and October of 1999. And with regard to the conversation with the unidentified individual and Mr. Lammert's conversation with Ms. Ray, each of those things, by definition, occurred after October of 1999.
Counsel, I wonder if you could speak further to the scope issue in terms of how this prescriptive easement has been framed. Is the testimony that the entrance to this back parking lot was always along the wooden fence? Was it from both entryways? What's the testimony?
There are two turnoffs off of West Main Street onto 1335, with one of which being directly next to the fence. That's the property line fence that leads back across the property line into this entrance. And that fence was replaced, even Wayne Ray conceded that fence was replaced just as it always had been. So the entrance to the 1337 parking lot has never changed. It has just been blocked by the plaintiff's predecessors in interest once Dr. Gardner vacated 1335.
I mean, in terms of traveling across 1335, is there evidence in the record so there are two different entryways to 1335, is that correct, from the public streets here?
That's correct, but we would assert that the scope of this easement being across the paved expanse is drastically overbroad, because it eliminates the possibility of my client doing anything with their property, because they have to leave effectively 80% of their property open as a paved expanse pursuant to this trial court order. It is drastically overbroad, and to the extent it exists at all, which we contend that it shouldn't, it should be limited. Unless the court has any other further questions.
Not seeing any. Thank you. Thank you both. Very interesting case. Most people say they don't want to have interesting cases. They just want to have cases that get answered.